A very good evening to everyone joining us this evening from different platforms. So, today the webinar is going to be a little different from the webinars that we do usually. We're going to step a little, in another direction, and we're going to talk about something that is very important but is not much in the conversation. So, I think if I have to describe it in one word, it would be communication. So we're going to talk about an advanced form of communication. We're going to talk about negotiation, about mediation, and how these things can help a person both personally and professionally. Communication in itself is so underrated and so underestimated today that we do not understand its importance and the consequences that one may face in the professional field or personally if the person is not abreast with various ways that a person can go about different negotiations, different situations. So, for that purpose, today we have two trainers with us. That is one, Mr. Advocate B.C Thiruvengadam. Sir, may we please have you on the video? And another one is going to be Mr. Anish Quenim. I'll introduce both of them to all of you briefly. And I'll tell you their introductions are uh, in themselves so interesting. They're interesting than the sessions themselves. So, Mr. Thiru is a lawyer of over 40 years of standing at the bar. He has a degree in commerce and law from the Bangalore University and also an intermediate in the chartered accountancy. He is a patent agent of the Government of India, a certified US patent process prosecutor from Sci Center, Sunnyvale, California, and a certified mediator by ISDL San Francisco and the High Court of Karnataka. He's also the senior partner at Thiru and Thiru, and that's a legal 500 law firm, and he's also a Group A counsel for the Government of India Supreme Court, and he is an internationally acclaimed mediator and arbitrator, and has resolved several cross-border disputes in the areas of corporate, IPR, fashion, commercial disputes, and he was also involved in establishing several court annexed mediation centers in India, including the Bangalore Mediation Center. He's also the master trainer of trainers in mediation and arbitration, and has trained hundreds of lawyers, judges, company secretaries, chartered accountants, engineers, bureaucrats, and he's also the co-founder of Bangalore International Mediation, Arbitration and Conciliation Center, that is BIMAC, which is India's comprehensive institutional ADR center with rules in consonance with the United Nations Commission on International Trade Law, that is UNCITRAL. And he's an executive committee member of the CII's Task Force for Dispute Resolution in Delhi. He has won several global recognitions. He's featured as in the prestigious LexisNexis 100 Legal Luminaries in 2016, Legal 500, Chambers and Partners, Asia Law Journal, and Asian Business Law and Marquis, and Who is Who in Asia. He was also conferred with Cambridge University International Professional Award in 2010, and he has been recipient of the Asia Law Journal's Leading Lawyer Award. And on 27th April 2017, David A. Clark School of Law, University of District in Columbia, has honored him in recognition of his contribution to the worldwide legal community. Thiru sir, it's our honor to be in your presence. Thank you so much for joining us today. And Mr. Anish Quenim, yet another, first I'll say he's a beautiful human being first. He is a great person to always talk to. He's a great speaker and communicator. Anish is basically a community policing specialist and a law enforcement certified hostage and crisis negotiator. He's certified from the United States of America, and he serves on the advisory board of Hey Blue, which is a community policing organization in Florida, USA. And he also heads the Department of Crisis Negotiation at Icebreakers in India, and that's an organization that prepares uh, for response to and also helps humans rehabilitate from crisis. That's both personal and professional. And Anish is a faculty at Maharashtra NLU, National Law University, and also teaches with us at Lawyers Club India. He has had various sessions with us, and he's going to teach another course that's coming on Lawyers Club India, which is going to be Negotiation Blueprint, where Thiru sir and Anish, they both are going to share their insights. And he's also an ongoing academic in criminal justice and social work with a focus on evidence-based community policing for crisis negotiation. And with the many ongoing projects with law enforcement, Anish specializes in relational policing by studying the evidence to assist in crisis de-escalation. Thank you so much, Anish, for joining us this evening. So, so the objective of being here with Anish and Mr. Thiru is that we're going to talk about negotiation. And while Anish will tell us what what the concept of negotiation is, how do we go about it, how should we plan a negotiation, what are the various steps in negotiation, Thiru sir will tell us how it is applied in the courtroom. He will tell us about the weaknesses in litigations, why is negotiation, mediation, ADR basically needed in India, and so forth. So first of all, Thiru sir, if I can request you to introduce to all the participants the concept of negotiation from the perspective of a legal professional, and also tell us about why do we have to, like, how has negotiation helped, and why do we have to take the matters outside the court? Are they is that beneficial or not? How is it beneficial, and what are the strengths and weaknesses of both the systems?
Hello. Hello.
Yes, Thiru sir, we can hear you.
Mr. Raghav?
Yes, sir, we can hear you.
Yeah, because screen froze for a minute. Okay. Thank you, Mr. Raghav. And thanks a lot, Mr. Anish, for inviting me to be part of this panel. Thanks to Lawyers Club India and all the participants who are eagerly awaiting to listen to us. Raghav gave a very elaborate description of introduction, I should say, and it's too elaborate, of course. But I'm here to share my experience as a lawyer, as a neutral facilitator in mediation as such. The topic here today is hammering down a negotiation. It's important for lawyers as to how negotiation plays a very, very critical role in the profession. Before that, every lawyer should realize how important he or she is to a society. Lawyers are very critical for a vibrant democracy. They fight to uphold the rights of the citizens, and you can call them as champions to defend the Constitution as such. They have a responsibility to highlight the duties of the citizens of a state and play a critical role in nation building. As a part of the process, we lawyers advise clients. Clients come to us for various requirements, not merely litigation. For several non-litigation work, they do approach us to, which we call as deal making. Lawyers are also responsible for creation of records and documents, and commonly known that we help clients in the litigation, and we have a responsibility to the court as we are officers of the court. So if you understand these these features, a lawyer plays a very, very critical role for survival of democracy and for a vibrant development of the country. But to what extent the lawyers are significant today, by realistically speaking, in India, when we got the freedom, it was the lawyers who were in the forefront, be it Mahatma Gandhi, Nehruji, or whoever, all were stalwarts. But today, there are lawyers, no doubt. But are we enjoying the confidence and trust of the parties or the public? In 2008, a survey was conducted by an organization called L'Exquisite. And we were shocked when we got a result that only 9% of the disputant population come to lawyers. Only 9% of the disputants like to go to the court to resolve the dispute. 51% do not even make an attempt to get the disputes resolved for various reasons. It may be cost factor, maybe time factor, maybe social stigmas, or other constraints. And about 31% of the disputants use untrained intermediaries to resolve the disputes. They may go to, if it's a family dispute, they may go to someone, the head of the family, or community leader. If it's a trade dispute, they go to a leader of in the particular trade or profession, and so on and so forth. And sometimes what people can go to a politician to resolve, or a civil matter dispute can be converted into a criminal dispute and you take a different clothing as a criminal matter, go to the police to resolve the dispute. But equally shocking is 9% of the population, disputants, go to the underworld. They go to the mafia to resolve disputes. To evict a tenant, why should I waste years and years fighting in the court? I'll use Muslims to throw them out. To recover a debt, people are using it. It's being done. So alarmingly, it's slightly more than 9%, I should say, about 9.6%, and definitely more than those people who come to, the percent of people come to lawyers. So friends, there's a complaint that there is docket explosion. Courts are slow, courts do not dispose cases, they're very, very slow, etc. Imagine only 9% of the population coming to courts. We say that things are slow. If 1%, there's an addition to the litigation tribe who come to the court, what will happen to the system? Are the lawyers losing faith, or the public losing faith in the lawyers? Going by the statistics, it looks like that. So lawyers have a better role to play. As what? They have several roles to play. One is as an advisor, as a communicator, as a litigator, as an evaluator, or as a negotiator. How many lawyers fit into all these 5 categories? As I said, that a litigious society is not very good for a country because it stunts the growth. But at the same time, a litigious society talks about the awareness of people being aware of the rights But disputes can be channelized, or even disputes can be avoided if the lawyer is able to assist the client in any deals that is going to be structured effectively even before a dispute arises. Most of the disputes, commercial disputes, are fallout of contracts. How is that the contract gives rooms for these disputes? Okay. So talking about disputes, or talking about negotiation rather, there are questions. Fundamentally, what is negotiation? Why do people have to negotiate? If I want to go and buy something in the supermarket or go to a mall, all that I do is go to the departmental store, pick certain things, put them in the basket, and come to the counter, use the bar, and the counter person, billing agent, scans the barcode and takes the bill and gives it to you. And you have to pay, and then you walk out. Is there any negotiation that happens? Okay. I go to a grocery shop. I want to buy some fruits. Okay. These may say, okay, the apple costs 200 rupees a kilo. I say, okay, why can you give me 2.5 kilos? Can you give me a better price? That results in negotiation. But when I start bargaining on the price or bargaining for extra issue, maybe I like to have a couple of more apples more or better quality or something like that. Bargaining fits into negotiation as such, but bargaining alone cannot be called as negotiation. But negotiation can be a standalone process where there is no bargaining. Okay. Now, there are various types of negotiation. There is direct, where parties directly negotiate. It can be before that. Negotiation can happen not only in disputes, but in deal making. As lawyers, you may like to negotiate on, a party may try to negotiate in mergers and acquisition of companies, or acquiring a property, or acquiring a right, or even a partition among the family members, family properties, so on and so forth. Or in a matrimonial dispute, that there may be a negotiation between the husband and wife who want to separate. So there can be a direct negotiation. And there is a variance to it that where there can be intermediaries also. Okay, I don't want to negotiate directly. I may ask someone, my agent, to do it, my lawyer to do it. So the lawyers and lawyers meet, the agents and agents can meet. So it's an indirect way of negotiation. There's a combination called hybrid negotiation, where I also take part. I may get involved in certain decision making or the final decision making, but I allow my representative to negotiate with the representatives of the other party. It's a hybrid system as such. Then finally, we have what is called assisted negotiation process. This assisted negotiation process is what we refer to as conciliation or mediation. But it's done by a neutral as is an independent person. I'll talk about it briefly. So these are the 4 types. Broadly, we call it, we can classify negotiation as such. But unfortunately, there's a study which was conducted by the University of Manchester, by the Manchester Business School, which says 50% of direct negotiation in commercial transaction, and especially in mergers and acquisition, fail. 50% of the negotiation, direct negotiation, fails. So people use the services of middlemen like merchant bankers or investment bankers to negotiate a deal. There are intermediaries who come in, which improves the chances a bit. But when it comes to dispute resolution, 95% of the direct negotiation fails. The success rate is just 5%. So that being the case, as a lawyer, each one of us can play a major role in assisting our respective clients or the parties in the negotiation, help them to negotiate better. As I said, you as a lawyer, you're primarily going to advise your client. You're going to evaluate the merits and demerits of a proposal, be it in a deal-making transaction or a dispute resolution transaction. In order to do that, you should be a very effective communicator. Your communication skills should be excellent. Why do you require communication? Because you'll be able to understand your client better, and your client also understands what is being proposed by you or suggested by you or advised by you better. You should understand the opposite parties. You should understand the lawyers or others assisting the other party. And when it comes to litigation as such, apart from this, you should also have knowledge of law and understand the mind of the court. So you play a very, very important role. And if you have all these factors, then you can be a very good negotiator too. And the course that is being envisaged will touch upon as to what is negotiation and why should one negotiate, when should one negotiate, the various styles of negotiation and various stages of negotiation, and the kinds of bargaining that goes on. And what happens, how do you help a party when there is an impasse, when there's a deadlock? How do you break it? How do you take it forward? So as I said, as a lawyer, negotiation skills are extremely necessary. Whether you're a litigator or a non-litigator, you want to practice on the corporate side or intellectual property side, whatever may be the thing, unless you're sitting before a computer and doing data entry operation or what is that, feeding forms and giving assistance to legal support services. But when there's going to be interpersonal interaction between two or more persons, then as a lawyer, you'll be able to be a very effective advisor, representative, intermediary, or assistant neutral facilitator. Now, when I talk about assistant neutral facilitator, I refer to one becoming a mediator or conciliator. Now, what is mediation? Mediation is a voluntary process where parties at dispute or even deal making would like to appoint an independent person to act as a facilitator and helping the parties, helping themselves to resolve the dispute. And as a mediator, when I say you are independent, that a person is not interested directly or indirectly with respect to any of the parties or with respect to the subject matter of the dispute. The mediator is expected to be absolutely neutral, unbiased, does not take any sides. And the process, we call it as a facilitative mediation, where we do not evaluate who's right and who's wrong. We are not judgmental. The mediation process is a non-adversarial process. It is party-centric more than lawyer-centric. In the courts, the lawyers play a very important role. But in mediation, the parties are given the importance. It's not that the lawyers are not needed at all for mediation. There's a separate program which is called as advocacy skills for lawyers in mediation. Lawyers need to be trained as to how to support and advise a client in a mediation process. It's a special skill. Such programs are offered to train lawyers to be specialists in assisting the parties in a negotiated settlement. That apart, the mediator does not render an opinion or even give a suggestion as to how the parties should settle. Then why should I be a mediator? If I'm not going to give an advice, I'm not going to give any opinion, why should I really waste my time and think, why do the parties require these? Well, that is the magic of mediation. It's all about. The entire magic of mediation is that we earn the trust and confidence of the parties. If the parties sense that you are not going to be neutral, you're a bit biased, or you're not independent, they are not going to pour out their heart and tell whatever they want to say, which they would not have done at all in any litigation process or before an arbitrator. The beauty of mediation is that, as I said, it's voluntary. Any point of time, they can walk away. But once they sign in a private mediation, a document called a settlement agreement, it is final and binding, can be enforced in the court. In a court annexed mediation, the court refers a matter under Section 89 of CPC. Once a settlement is arrived at between the parties, it has to be blessed by the court and a decree is drawn, and it's final and not appealable. The beauty of mediation doesn't take much time. An average time taken for mediation is about, in India at least, I can tell it's about less than 2 sittings, about 111 or 112 minutes per session. But mediation is as such as gaining a lot of popularity. So what goes into a mediator? In the beginning, Raghav said, communication, yes. You become an expert communicator and also help the parties to communicate with each other better, so that the parties are the one who determine the outcome of the dispute, not you. And you're not a judge nor an arbitrator. So it's a question of self-determination. And how do you do it? With good communication skills, which you help the parties. With good negotiation skills, again, you help the parties. And you have the knowledge as to how to break an impasse and help them to come out a lawfully agreeable mutual settlement. So negotiation plays a very important role for a lawyer. For a non-lawyer, you may be anything. You may be a chartered accountant, a company secretary, or even a housewife, or any homemaker, or anyone as such. Negotiation is a very integral part of human existence. You can't say, oh, there's no negotiation at all in my life. Thank you.
Thank you so much, Thiru sir. This gives a macro view of everything that we're going to learn, that there's everything to negotiation. Thank you so much. Beautifully explained.
Thank you.
Anish, can I please request you to tell us how did you find your way to negotiation, and how do you define it as a skill that is needed in the present time? And also telling the participants about the course that is going to come, that the one that you're going to teach, and how it is going to be helpful for everyone.
Yeah. Thank you, Raghav. Thank you, Lawyers Club India. Thank you, Thiru sir, and everyone for being here. And of course, all participants and a lot of my friends who are present, thank you for being a part of this webinar. In fact, Thiru sir has made it so easy for me to answer that question for you, Raghav. And I'm going to actually summarize a few things that he said, which will allow me to give you my introduction. When he says lawyers defend the Constitution, it pretty much relates to what I'm trying to achieve with policing and with law enforcement when I'm saying, if we are not law enforcement specialists, if we can just change law enforcement to law protection specialists, that becomes so much easier for communities to relate with us. Look, today, if we speak about the police, I'm not talking in general that every police officer is possibly not the best, but like how Thiru mentions that 9% of people are only confident to possibly come back to a lawyer or ask a lawyer for assistance. I think that would be 0.9% when it comes to policing, to possibly approach your police officer and ask him for help or ask him to assist you. And, can disputes be channelized? Can disputes be avoided? Can lawyers play their role to help this never happen? Just let's replace the word lawyers with police officers over here. Can we in law enforcement avoid crisis from happening? And that was precisely why I decided to get into this line of hostage and crisis negotiations. But my introduction it followed post Raghav speaking about the fact that I'm a community policing specialist. And what I like to do is exactly the last line that Thiru sir said, is earn the trust and confidence of the parties. Now, how do you earn the trust and confidence of the parties or of people you're going to work with? Is by working back with them. If you're going to knock on their doors on one fine day, or if they're going to knock on your doors on one fine day, you haven't really built up to that being a facilitation for a settlement, or that being a reason for them to come together and channelize their way of thought to make something work out. So my foray into policing was more understanding why a crisis happens. Why is it that people are leading to a dispute? Why is it that two parties have not been able to come together? So community policing allowed me to work back with communities, knock on people's doors when they didn't need us. And that was really fun, because knocking on someone's doors on behalf of the police, saying, hey, my name's Anish and I'm here from your local police department. I'm doing a project with them, and I'm actually a hostage and crisis negotiator, but I'm just here to say hi. I'm just here to ask you, how was your day? There was no need for them to speak with me or me to speak with them on that day, but nothing stops us from this basic aspect of humanity, of just smiling, of saying hello to people. Because when the crisis does happen, when the dispute does happen, the trust and confidence that we built prior allows us to lead up to that day when we can actually work towards resolving the dispute. And I'm going to quote a quote which is written by a very close friend of mine, where she says, embrace life and use both positivity and negativity as a fuel throughout your journey. But more importantly, always remember your roots and never forget the people. And this was written by one of my friends named Nitya, who is one of the best marketers I know. And the reason I'm quoting this right now is, we are working with people. We are working with human beings. We're working with blood and flesh. We're not working with machines. And when we work with people, we try to understand their emotions. We try to understand where they're coming from. And it's only when we understand that they have come to us because some aspect in their life has not received closure, that very important aspect, and I'm going to repeat it. They have come to us, or they require our help, whether it's law enforcement or whether it's the legal fraternity. They have come to us because they have not received their closure. And they look to us to find that closure for them, or to find ways where we can arrive at a certain moment in their life where they can get it past them and go beyond it. So this is really important for us to understand. The reason I quote what she said is we are trying to sell, we are trying to market closure. And one of the greatest ways of doing that is by humanizing ourselves. Look, we wear the badge of a hostage negotiator, or we wear the badge of a lawyer. And when we meet people, there's always that, oh, these guys have come from this profession, and we don't know whether they want to earn out of it, whether these guys have an ulterior motive. But that's not the point. The whole point is, hey, we're here as human beings. And when Thiru sir mentioned that there are many untrained dispute resolution specialists, that is precisely what is happening in our communities. There are a lot of people who may be untrained, but the difference between them and us is they make approachability a very key factor in their lives, which we tend to miss at times. And if we can make approachability a factor which we can show out to our communities, hey, we're trained, hey, we know how to help you. And here we are making ourselves approachable, which means that 9% could go up to 10% and possibly 20% and maybe one day 100%. So that was my foray into community policing instead of hostage negotiations. Yes, if someone does come to me, someone does give me a call, if someone does say, hey, I'm in a crisis, can you help me? Of course, I'm going to help you. Of course, I'm going to be there to help you. But what if I can work with them in a way that day never happens? And that's how I moved back to move forward. And one thing which I really practice is the other perspective. This is a very important line which I would like listeners to listen to. And whether you come from any background right now listening, it's not just a legal background. If you want to have a communication going forward, you got to remember that there are always two perspectives. One is yours, or one is the one you're representing. And the second is the perspective of the other party. Most of the times you may believe that the other person's perspective may not make sense to you. But if you make the other person believe that, hey, I know you are going through something right now. I know there's something that you expect out of this discussion, which we're going to have. And I have listened to you and I've heard what you're trying to tell me. That may facilitate further communication. And, we always speak, even Thiru sir mentioned it, Raghav mentioned it, that communication is a very key aspect of negotiation. But please keep one thing in mind. When we say communication, we go all about speaking, we go all about talking, we go all about putting our point across, we go all about, hey, this is how it could be done, this is how it should be done, this is what the law book says, this is what the rule book says. Yes, we have to follow all those books. But remember, number one, the greatest aspect of communication is listening. It's not speaking, it's not talking, it's not always saying something which you want to say. And I've seen that at the police department where I used to work, that people would come in there with their disputes. And if I had to begin with, hey, this is the rule book, and this is what's going to happen to you, and this is where you're going to lead to, and this is where your family is going to go and where you're going to go, we're done. We're done. The matter has ended right there. But at that point of time, if I can spend 5 more minutes with that person, just saying, hey, I apologize for the fact that you had to come here. Even if the person's in the wrong, is there anything I can do to be there for you right now? I've suddenly opened up the doors for trust. I've opened up myself and my heart to that human being. I've shared humanity in a way in which that person understands that, hey, there is someone out here who possibly understands the other perspective. And that's very important in a negotiation. So always keep that in mind. Please remember the applicability to hostage and crisis negotiation. A lot of people are going to wonder, what is a hostage and crisis negotiator doing in this webinar? I'll tell you what I'm doing. When I'm at the edge with people and they've taken something hostage, taking something hostage would normally be a property which means something to them. It could possibly be a person that has done harm to them or will do harm to them or has caused harm to someone really close to them in their life. So they're holding on to something which means possibly well to them or possibly something which they don't really care about. But they're open to listening. What do you hold on this side? I hold their freedom. I hold their ability to want to walk out and see a better day. And if I have something that they have and they have something that I have, we now facilitate communication. So even in hostage negotiations, I'm always trying to understand, why has the person taken that situation hostage? Please remember what I'm saying. I've replaced the word person, I've replaced the word building with the word situation. Why has the person taken that situation hostage? And if I can understand why the person has taken that situation hostage, if I can listen to the points that he's trying to put across to me, it becomes very easy for us to then facilitate a communication. And I was mentored for 2 years by an ex-FBI agent who was one of the lead trainers at Quantico. And I worked with him at TPI International, which is third-party intermediary. And he taught me a very important aspect of negotiations. He said there are 5 things which allow you to actually negotiate. And it's called the behavioral change stairway. Number 1 is active listening. We have to begin by listening. Unfortunately, what we do is on that stairway, the last one is behavioral change. We want to effect change in behavior the moment we start speaking with people. The moment someone comes to us, we're like, oh, we have the solution for you, and this is where we're going to go, and this is where we're going to head, and this is where life is going to actually take you and take me and take all of us. No, hold on. At this point of time, I'm sitting in front of you, I'm sitting with you, and I'm listening with you. And once you listen, you move to step 2, which is empathy. Once you can show that you empathize with that situation, you move to step 3, which is rapport building. And once you build a rapport, you can actually influence, which is number 4, you influence the person towards behavioral change. So this is a very important aspect of negotiation, which I learned from my mentors at the FBI in the United States, that if you can take a person from listening towards behavioral change through a step-by-step process, you are going to allow communication to find its way through. And I'm quite sure Raghav would have a question coming as to, hey, do all negotiations succeed? Do all negotiations fail? I definitely am going to address that question when we get there, because even us, we may not be successful 100% of the time. And I'm sure Thiru is going to back this, that we're trying to help you. We're trying to negotiate and bring you towards an amicable solution, towards an amicable settlement. But sometimes, even though it doesn't work out, there are a lot of little things inside that, or little aspects in that compartment which work out, which may facilitate an actual closure for someone. So that's what I have to say. And we've really put this down together into very finer thoughts, into finer chapters, into finer courses. And it will be taught to you all at the course which Lawyers Club India has put together with Thiru sir and me. And I really hope that we can elaborate on these little aspects of negotiation which allow us to humanize ourselves, humanize that situation, and allow people to reach towards closure and a settlement.
Thank you so much, Anish. It's always a pleasure to listen to you. So before moving forward, I'll just appreciate the fact that two very experienced people, and not only experienced but experienced in fields which are very, very critical to each one of us: the machinery, the law, the police enforcement. They're going to teach us about negotiation and how we can be more comfortable as a society. Also, when we talk about negotiation as a career that we're going to choose professionally, we're talking about taking up a learning negotiation for our profession or professional growth. It's not only about us personally, but also a lot that we can give to the society, as both the trainers have spoken about. Also, one thing that I have noticed, and also I'll tell people, I've received questions from people about the course. What is it going to teach us about? So one thing that I could gather from both the speakers speaking just right now was that we surely are gonna, learn from the course how to process information and put it forward to the audience. How to put it in a way that everyone is comfortable listening to it, then processing it, then understanding what is on the table, and then we all can, mutually benefit from what comes out of that conversation, or that understanding, or the thought process that goes into it. And also, everything, all these things, how lawyers can use that in the courtrooms and the situations that they find themselves in usually. So moving on to the next question, Thiru, can someone prepare for negotiations with respect to the various situations that, so particularly talking about lawyers, can they prepare for a negotiation that they might head into? They might, uh, you know, want to negotiate with a client, with a co-lawyer, with a judge, or any other situation. How can someone prepare for that?
It's a very good question, Raghav. Anything when you're dealing with respect to someone's right or life, then it's always advisable to prepare oneself. But there are certain things which require a temperamental adjustment over a period of time. As Anish mentioned, one of the basic quality for a negotiator is to listen. Should have immense abundance of patience to listen. Not to cut someone to size and interrupt and say, come on, I've heard you enough. Don't be repetitive. Okay? This is one of the few, the moment you do that, you're putting off someone, and the other person is going to withdraw. He may feel insulted or may suffer from various complexes. So we normally do not interfere at all. And there are ways to listen to a thing very patiently. So these are to be done, not these are techniques of what's going to be taught in the program as such. These communication skills are going to have to understand very clearly. And there is no a straitjacket method for communication as such. But preparation insofar as a negotiation is concerned, then you need to understand who is your client. What are the client's demand or aspirations or the client's concern? Similarly, if you're negotiating between two parties, you should understand the concerns of the respective parties. At times, there may be a lot of legal issues, impractical suggestions, and fanciful demands. Okay. So how do you tackle them? So a little bit of homework is necessary to understand what is the issue between the parties, how best you'll be able to help them out. And negotiation is slightly different from mediation. In mediation, when we say facilitative process, we don't evaluate and say who is right or wrong. But if it's pure negotiation as such, people can be free to point out, okay, in my opinion, this is not acceptable. What you say is not acceptable to the other party because they feel that you have done these things wrong. Maybe why don't you put it in a different manner? What sort of options can be generated? It can happen only in negotiation, or as we call also in conciliation, but never in mediation as such. So it requires a bit of preparation. And as I said, there are one is you have to be patient and understand, don't be hasty in talking as such. We do less talk as such. And this is very important. Lawyers tend to talk. Yes, you're at liberty to go and argue at length in the courts. But when it comes to negotiation, nothing like remaining silent and active listener as such. But with the subject matter of the dispute or a deal, try to understand. And if you have a domain expertise, it comes to a great advantage. Little bit of research about the parties, about the industry, or about the background of the community, whatever it is, it will definitely help. So it does require a little bit of preparation.
Thiru, if I may add to what you just mentioned, one very important aspect which we use in at least in law enforcement, if we are going to negotiate with people, is the ability to be mindful and the ability to presence yourself. And that's one thing which I've seen that doesn't happen very often, is being in that moment, being present in that moment without allowing distractions to hit you. And I know that all of us have so many things which we're working with in life. We're switching on, switching off. We're going from one core to the next core every second. In fact, right now, when Thiru and me finish this call, we're heading to the next thing and then the next thing after that. I'm sure most of the participants from here are pretty much going to be having that agenda. So, and this is a line which we got taught in our hostage negotiation classes: never get taken hostage yourself. So even when you're in that moment, when you're presencing in that moment, there are so many things which are said to you, which you may hear, and you may want to put yourself in that moment and say, hey, what if it was me, and what if I could do it? So we need to learn to disconnect ourselves from that place, but yet be very connected. And that's a skill which we will teach you in the course, which I'm quite sure you're going to really enjoy, as to how you can be present in that moment completely, but yet emotionally detach yourself so that you allow the client in front of you to be heard. And another thing is, seek to understand, which was shared with us with one of our hostage negotiators from the US called Scott Tillema. He says the word seek to understand. If you can seek to understand what the other person is trying to tell you, that itself is preparation. And another aspect of preparation is profiling, evidence analysis, and situational awareness. If you can get these three aspects, which is profiling, evidence analysis, and situational awareness, which we will teach you at the program, and just understanding that, hey, this is what the situation is all about. And if you can plot and plan your way around it, it'll be very easy for you to prepare. So it's preparation for yourself. You need to be fit for that moment. And more importantly, you need to prepare for the case, as Thiru sir says, so that, you have some knowledge, you have some aspect, and the person who's in front of you doesn't believe that, okay, I've actually had to tell everything to this guy, so why am I even here? So I just thought of adding that to what you're saying, Thiru sir, if that makes sense.
That's absolutely. There's no dispute at all. We agree on this thing. May I also add one thing, very important aspect as a lawyer and as a mediator. Your reference to hostage negotiation is quite relevant even for mediation as such. I find there may be a few mediators, at least one I notice here. There are situations when you're dealing with family-related disputes, especially matrimonial dispute, or involving elder thing. In a family dispute, what happens is that when the spouses are fighting, the victim as such is the child. There's a child custody issue comes in. Okay, it's not a hostage in person as such, but the child is used as a pawn in a dispute between the husband and wife. One claims the custody of the child, and other says no. Okay, maybe thoughts from Anish can really be helpful in resolving such dispute when it comes to mediation. Similarly, when it comes to senior citizens who are at the mercy of the children, or neglected, or there is a dispute among the siblings, the senior citizens again are placed in a similar situation. They become helpless. They don't know what will happen to them. Okay, they're in a position of such a situation as being a voluntary hostage, or living with someone much against their own wish. They don't have a better option. Okay, so these things which come across a lot while we do mediation as such, and we try to help people to resolve this. And I'm sure Anish's input will be very helpful to mediators too in this regard. Thank you, Anish.
You're very welcome. And I completely agree with what you're saying, that, people take emotions hostage. It's not just them that are affected, but there's so many aspects around them, people related to them, lives related to them, communities related to them. And I love the fact that you mentioned that lawyers play a critical role towards survival of democracy and development of the country. Similarly, in our line, what we do with people plays a very vital role towards survival of the families, of democracy, of upliftment of economies, of countries. And if all of us can play these roles and understand that, hey, there are lives attached to us which are directly and indirectly affected by what we do, what we say, what we wish to say, or what we even wish to claim from a dispute, we would be able to humanize ourselves to come towards a settlement.
Thank you.
Thank you, Anish. Thank you, sir. Also, one thing that I noticed from the conversation that Thiru sir and Anish were having is another skill that we might get to learn in the course is to apprehend what people who are listening to you are going to ask next. So we already know that once we have communicated what we had in our mind, we know what else the person is going to ask, and we're already ready with it. So that is the kind of understanding that we can build, and once we have built it, it's gonna come handy in your life as a lawyer, or as any professional, or personally also. So moving on, Anish, a question for you is that how do you, so building on what I had asked Thiru sir, how do you think a person can best go about a certain situation or plan his way through crisis? So maybe some examples maybe that you can share, and how does a negotiation crisis actually really works? And if you can, break it into different steps, how a
Yeah.
negotiation works.
Yeah, absolutely. I'm gonna quote an example from my time with law enforcement. We had a neighbor. Now, this neighbor who lived in one of our communities was a very noisy neighbor, and before I reached that police department, it wasn't possible for almost 20 years for them to resolve that dispute that she was having with her neighbors. Now, this is a 20-year-old dispute which is stuck at law enforcement, is going up and down to the magistrate, it's coming back to the police department, it's going to court, it's going out of court, it's coming back here. And the first time when I walked into that PD and I said, the PD's police department, and I said, hey, can you tell me some of the most difficult cases which you all have not been able to resolve? And they mentioned about this neighbor. And what I did on the first day was I understood what was her favorite ice cream. And it was apparently strawberry. And I picked up a tub of strawberry ice cream and I went to her house to say, hey, I've just moved into this department and I'm going around meeting my community. And I heard that you really like strawberry ice cream. So I've got you this tub and I hope you enjoy it. And it was just that. And we resolved that dispute within 21 days. So what didn't happen in 21 years happened in 21 days. And the background story of that was I wasn't just spending time with her. I was spending time with all the parties affected by her. I was understanding what were her hooks, what were her triggers. These are two very important aspects which we will teach at the course. So what is a hook? A hook is something that really lets her hold on to you, and a trigger is something that really, just blows her fuse off and just takes her away from that discussion. So this for me was one of my most special cases where we managed to resolve a 21-year-old dispute in 21 days. And there was a lot of gratitude coming in from everyone, because as Raghav mentioned, that we are all instruments of justice, whether it is the legal profession, whether it is the police profession, whether it's the correctional institutions. We're all little instruments of justice at the end. And if we can all play our role by going one step beyond what we are normally supposed to do, it may lead to a lot lesser of that happening. Going on the flip side, there was one case which I was handling, which was a business settlement, which was literally going off tangent for really, really long. And what I played, the role that I played in that case was I allowed them to stall for time. Now, stalling for time is a very important hostage negotiation masterclass, which we are taught through trainers in the United States. So stalling for time basically means that, hey, even though we know that this negotiation may not conclude in the manner that we want, we are trying to understand the client. We are trying to understand both sides of the party in a way in which we can prepare our defense, or we can prepare our action in a better way, so that once we move we move the court, or we move the police administration to take action, it may lead to a settlement because we have spent more time understanding it better. So even though a negotiation might not work out sometimes, you're actually stalling for time to get more facts in. And factual analysis, data analysis, understanding why. And this community member, this neighbor that I spoke about, I understood why. And it all boiled down to the fact that she hated people trying to help her in a uniform. And if we wore a t-shirt and jeans and went to help her, the same people without the uniform, she loved it. She loved having a conversation with us. So it was these little hooks and these little triggers which we picked up from this conversation. So yeah, that's my give back to listeners in this is, if we can spend a little bit of time understanding why it's gone wrong versus, hey, this is how it actually should be done, the answers would come from the person. The answers would come from the opposite party. The answers would come together, because a negotiation happens when both of them want to walk a common ground. If it's an unreasonable negotiation, hey, there's nothing you can do apart from trying to get them on the same ground. But most of the times you are able to achieve it.
Thank you, Anish. Again, picking up from what you talked about, I think it's for lawyers, it's not just, one thing that we can learn is that it is not only about the pile of documents that you've received from one client, or that just one person that you have to focus on. There, you might help yourself and your case with other parts of the frame that you can observe, and you can identify what parts can you work on, and then they might come handy in the courtroom and other places. So I think patience, observation, and identification would be the key to success on this.
Yes, and the other perspective, Raghav, as I mentioned in my second point, understanding the other perspective. If you can understand the other person's perspective, okay, this is what your client wants, right? We know that. but why does that client want what this client has? And that allows us to facilitate a negotiation.
Right. So, moving on, Thiru sir, I'm sure you have a vast experience of 40 plus years, and maybe you can share with us some tactics that might come handy for a lawyer or a negotiator when they come face to face with situations that demand, negotiation or dispute settlement through proper communication. So you're muted.
I'm going to cite an example where I was not playing the role of a mediator, but as a lawyer. Okay. There's a particular piece of land, a huge tract of land belonging to a client of mine, which was apparently notified by the local land development authority. And there was a dispute between this authority, which says that it has formed sites and given to various people, which falls within this land. Whereas I was defending my client and saying that no, this we will not allow you to take this land because your acquisition process is wrong and there's a defect. I succeeded in the High Court. This is a long drawn litigation, started in 1984, went on and on. Around 2000, it went to the Supreme Court. In the Supreme Court, the judge in the Supreme Court said, why this case is going on for several years? And I suggested, so basically, I believe that the identity of the land, the issue is with respect to identifying the land, and what the authority claims must be a different land and not our land. And I suggested to the court, why not we get this land surveyed? A survey was conducted, and the court said, yes, that's a good suggestion, go ahead for the survey. When we conducted a survey, I found just a small piece of land, as against about 16 acres of land. It's about 200 square feet of land from my client was falling into the area of the authority, not the entire land. So it was decided, I spoke to my client, listen, you're holding on to a huge piece of land, and it's going to go into litigation, and this is going to, we don't know how long to go on. Are you willing to give up this 200 square feet of land and save the rest of this? And it made sense to our client. So we had a direct negotiation with the authority, and matter went, we went to the court and said, listen, this is it. As long as we are willing to give up, surrender this 200 square feet of the land, and provided the authority doesn't claim anything here. And there were a lot of allottees. And the allottees by the authority who claimed that they should build houses, they were very happy, except for one person, that is the person whose site was supposed to be overlapping onto the land of my client. He was also happy because he's getting this 200 square feet of land too. Had this been done in the beginning, way back in 84 or 85, 1984 or 1985, it would have saved a lot of time, saved people their money. Those who have been allotted, they could have built the houses. And thereafter, and my client could have developed his property too. But strangely, and thankfully, the allottees from the authority, they were very happy. And you won't believe, almost all of them became my clients. Okay, some of them I still advise them. The first thing they come to me is, sir, is there any way we can get this resolved without going to the courts? Okay, so that has been a practice. Almost all our clients As a lawyer, when I represent my firm, we say, okay, why don't you have a negotiation? Have you had a direct negotiation? If not, let us have assisted negotiation, either through a mediator or even lawyers, and lawyers can talk. And in a negotiated settlement will never threaten a lawyer. The value of a lawyer gets enhanced, and I can vouch for it. And every time a matter gets settled, the client comes back to me with another matter, because he trusts the system, he trusts the court system, he trusts the court's mediation system, trusts the private mediation system or private negotiation system. So lawyers should not feel threatened at all that all ADR is going to take away their livelihood. On the contrary, it's going to bring more and more people into the people to trust lawyers and make them get so that lawyers can gain out of that. This one example I can give you. There are many such disputes. There are 22-year disputes. Matrimonial disputes got resolved in 3 sittings. There are several mediators in Bangalore who can really vouch for the success. They're all brilliant work they do, especially in the Bangalore Mediation Center. It's one of the Court Annex Mediation Center. They do a wonderful job too. And similar, I'm sure other mediation centers, they do a lot of work. So I feel negotiated settlement cannot be a threat to the livelihood of a lawyer, or as a matter of fact, any professional. It could really complement them with more and more work as such.
Thank you so much, Thiru. If I can ask Anish, if you can build on that and tell us what are some skills that a good negotiator should have, like just bullet them out.
Yeah, thanks, Raghav. I think that was a brilliant example quoted by Thiru. And I just want all the lawyers who are present over here to ask yourselves one question: do you want to be known as a lawyer who's a good litigator, who continues that dispute for as long as it takes, or do you really want to be known as someone who can resolve a situation? And that's how we looked at it at our police department. If we look at hey, you can dial 100 112 or 911 and we respond to that situation and we're there to help you, yeah, absolutely, that's our job. But hey, what if we can help you resolve that dispute without having to arrest the person, arrest you, arrest someone else? And that's so, and I'm going to quote these numbers. There was an 800% rise in the number of people that approached us because we were looked at as situational resolvers rather than people who were fighting with other people and saying, hey, we're going to get you justice. So there was an 800% rise. There was an 89% drop in crime in our communities. And that was big. For within 1 year to have crime to drop down 89% gave me this statistic, which I'm now going to mention, is the trust levels between community and police officers where I worked were up 100%. Anyone in our jurisdiction who was asked, do you trust your police? Do you trust going to law enforcement for assistance? They said yes. And this is really important what Thiru is saying, that if lawyers can look at, hey, this is that situation, this is how we can really help to resolve it really, really quickly, you're going to get a flurry of calls coming your way because you're going to be looked at as that one guy or that one person who can actually help you resolve the dispute. So yes, answering Raghav's question now, a few things which you need to keep in mind to be a good negotiator. Number one, please start listening. 2 ears and 1 mouth, basic. We've all been taught this in school. 2 ears and 1 mouth. Listen more, speak less, and of course attend our course, which we're going to set up because that will really allow us to elaborate on the basic aspects of negotiation, which will allow you to become a better listener. And more importantly, please work on your approachability. It could just be the way you speak, the way you talk, the way you listen, the way you stand, the way you post on social media, the way you speak in society, the way you speak with your family. That just goes viral. And when you become an epitome or a symbol of approachability, people are going to come to you for assistance.
Thank you so much, Anish. So I think we need to replace "I will fight this case for you" with "I will resolve this case for you." So that is a change that I think we need to introduce in the society as lawyers. We need to do that. Also, I think we have not exposed ourselves to the results of what a negotiation can do or what when we are talking about client coming back to you after you've resolved the issue quicker than the litigation could. So you could keep one client for years, and it's always uncertain. You cannot keep him feeding you for your life. Or you can go for several clients coming back to you again and again, and you resolving their disputes quicker, and then the word of mouth. So we need to expose ourselves to this idea, and we are only, if we are uncomfortable, we are only uncomfortable because we have not really thought about it or exposed ourselves to it as a society. And we can change, and we are changing it. So this will really help. So Tirusa, this is the last question. So because Tirusar has other things to attend to, we'll have this last question, and after that we'll take the questions from the audience. Tirusar, uh, once a negotiation is done with, and it's now time to build a contract, or do the practical drafting thing by the lawyers who are involved in the dispute resolution. Can you share some insights briefly on how does that process work, and how does good communication skills, good understanding skills, good negotiation skills come handy there?
Certainly. Ultimately, what is the point after detailed, lengthy negotiation if the settlement is not drawn properly? Again, it may go back to a litigation or dispute. So a lot of care is to be taken when it comes to drafting a negotiated settlement agreement. It's very important that the mindset of the parties should be that they're not compromising. There's a lot of difference between compromise and a resolution. Compromise is something what they're giving up, or may rather forced to give up. Whereas resolution is trying to find the optimum, the best solution at a given point of time. So when you're crafting an agreement, this should be borne in mind. Do not allow the element of compromise to creep in your document. It's not something one sacrifices or when someone is forces to give up. It's a question of a give and take towards a win-win situation. That's where you will look at. So the draft should be aimed at, as far as possible, a win-win situation. Now, what goes into a negotiated settlement is fundamentally all the elements of a valid contract. So if you're good in Contracts Act, it's going to be extremely helpful. Those who are not very familiar with or conversant with contract, it's better that they understand the Contracts Act thoroughly. Apart from Contracts Act, they should also understand the Specific Relief Act. These are two laws which I strongly recommend for anyone who is involved in drafting a negotiated settlement, be as a mediator, be as a lawyer assisting the parties. There are lawful contracts. A contract cannot be enforced if it is prohibited under law, or if it contravenes any law, or if it's opposed to any public policy. There are various provisions in the Contract Act which says what is permissible, what is not permissible. So please take care about this. Other than the Contracts Act, generally there are certain prohibitions in various other law, like maybe the Income Tax Act or any other law which prevents a person to have a contract which is per se illegal. So generally, one should be mindful about the legal aspects of a contract. Most important is make the language simple. Don't use any big language, legal language. Make it simple so the party also understands. There should be clarity. There should not be any ambiguity when you're drafting something. Always put yourself in the shoes of each of the parties. Empathizing is very, very important. If a particular clause is drafted in such a manner, is it going to be acceptable to each of the parties? Think in that manner. Okay. So avoid ambiguity and ensure that everything is lawful. And it's always better to use structure as to what you want to be written. Do not bring in unnecessary things. Do not have, as negotiation settlements should not have big history. Don't go back to the past. I've seen certain settlements being drafted. They talk about this, such a dispute exists. People do not want to look in. When you're arriving at a resolution, you have to look at the future. Forget the past. So do not bring your history back onto your document. It's my advice to those who draft a negotiated settlement, be it in a private mediation or in a court annex mediation or any sort of negotiation. Think always positive and be positive.
Thank you so much, sir. Great advice. Anish, can I ask you to tell us about how can you identify the walkaway point? When do you know that it is over? Now you have to step away from what's happening, and also tell us why and when does the litigation turn into negotiation, and how how best to go about it?
Firstly, for a hostage negotiator, there is nothing such as a step away point. If we step away, everyone's dead. So let me just begin with that we have no step away point. So we are very, very stubborn when it comes to resolution, getting a result. 96.9% of the time we succeed in a resolution, as long as it takes. We're present in the moment. The other times when it doesn't happen is possibly because we're dealing with severe mental health issues, or we require the help of support systems like psychiatrists, psychologists, clergies to actually tell us that, hey, if you use these aspects in negotiation, it might go through. So, but there are times when you need to realize that, okay, we've called spade a spade. We've tried to make this happen and it's not happened. But then I think this is a joint decision taken by many people in that team. It's not just me alone. So if the person's being unreasonable, you're again trying to bring them back onto path. And being unreasonable is not just your client, it's also the opposite client. Again, as I mentioned, everyone who has headed into a dispute is looking at some point of time for closure. If we can understand that when people are looking for closure, they would get tired. It's like a steam kettle, right? And when they begin the dispute with you, the kettle's at its most peak. It's just blowing steam out. But if we can allow that to settle a little bit, understand why it's going to blow steam up again, and get people to a common path, we will be arriving at a resolution. We will be arriving at both parties walking away from the table, as Thiru says, without the word compromise, but each one taking back what they've actually wanted. So yes, when to step away? That's a very wrong question to ask a hostage negotiator, because we will make sure nobody steps away. I will make sure that no one has ever stepped away. It has to resolve. But there are times when also stepping away means you're stepping forward because you've understood why it's not worked, and you can come back with a better strategy for the next one. That's what I have to say. And I don't know if I can add this with you, is a little takeaway message, since this was the last question before we head to the audience, is people keep asking me, hey, but I'm not a hostage negotiator. I'm not a lawyer. I'm not someone who does it. Why do I have to listen to webinars like these? And the reason I keep saying that is you are negotiating life every single day. You're negotiating decisions, behaviors, whether it's with your mom, with your dad, with your kids, with your family, with your neighbors, with anyone, whether it's even chatting on social media with a friend. What you say, how you say, when you say, how you listen, leaves the doors open or closed for the fact that you might require our help. Look, Thiru sir and me will always be there for you if you ever require help during a crisis. But if you can negotiate your life in a manner where we would never be needed, that would make us happier than the fact that you considered coming to us for help, because, hey, you've already resolved that. So you are negotiating life every day, whether it's even setting your alarm and deciding whether to press snooze. Most of us begin our day with that negotiation. Should we click the button snooze or should we just wake up? So please remember that it starts the day we wake up, and it ends the day we finally close our eyes. So please negotiate live beautifully. Do it in a way where, you wouldn't have to land up on our desk, but if you ever need us, we're always going to be there for you.
Thank you so much, Anish. Always making me jealous how you use the words. Also, one thing that I would want to spotlight is that when Anish said that stepping away might be a step forward, that's very important. When you have to realize that taking a step backward might be the right strategy forward. So, can I, sir, Thiru sir, can I ask you to share your insights on when is there a situation when lawyer needs to step away, or when he has to, it's a walk away moment for a lawyer? So you're muted.
It's unethical for a lawyer to prevent a negotiated settlement. If the client desires that there should be, he wants a negotiated settlement, he should support it. Okay. And at times, the clients would like to deal without the lawyers. Okay. And depending upon a situation, a good lawyer will understand a client better and may leave it entirely to discuss with the opposite party directly without the assistance of the lawyers. I need to mention this. I used to practice a lot in the company law boards. And there was a gentleman called Mr. S. Balasubramanian, who was the chairman for several years as the chairman of the company law board. Most of the company matters used to call them with the parties to the chambers and resolve the disputes. But he was very, very particular that none of the lawyers should enter the chambers. It should be the direct negotiation between the parties, and we'll be watching this. It's not that I'm being a lawyer. It's not that I'm saying anything bad about a lawyer, but there may be many things which a client likes to discuss personally, which he or she may not like to even discuss these things with the lawyer. So in such a way, if as a lawyer, if I can sense that my client wants to have a direct talk, and if I can sense that he wants not to be around, okay, I should step away. There should not be any hesitation as such. But all that I'll say is, okay, be careful. Don't put anything in writing till you're sure. If as a lawyer, I'll advise my client, think and then decide. Okay.
Thank you so much, sir. Now we'll take questions from the audience. You can share your questions on all the platforms that you're watching us from, be it Zoom chat or Facebook. Everywhere there's our team who's collating the question. So first question, Thiru sir, is for you. That is about the prospects in ADR. Mr. Vinesh wants to ask Thiru sir, what are the prospects in ADR? How do you compare this practice with the civil, criminal, and corporate practice?
The practice, see, ADR is a general term. There are various types of dispute resolution mechanisms. Okay, one is an arbitration, which people talk about. In arbitration, again, you have ad hoc and institutional arbitration, then mediation. We have institutional ad hoc mediation, institutional mediations. Then we have, again, a species of what is called as conciliation, which pre-existed mediation as such. And there are other systems like neutral evaluation, local adalat, and various hybrid systems, okay? Like MEDAR, ARMED, so on. There's so many combinations. As I said, there is frustration building among the disputants. They are looking at various other opportunities to resolve the dispute. When they can go to a mafia, 9% of the disputants can go to mafia. Why can't they come to choose any effective ADR option? So according to me, the prospects are great. And people will be moving away from litigation court systems. And that's what even our Chief Justice been saying, that he says, come on, we should have a law now which makes pre-litigation mediation compulsory. Okay, so the prospects are very, very bright as such.
Thank you so much, sir. So another question: isn't negotiation and mediation mandatory before a party approaches the court?
Except for commercial mediation, value is about 3 lakhs and above. Mediation is not, pre-litigation mediation is not mandatory. We call it as pre-institution mediation under Section 12A of the Commercial Courts Act, where before, when the values of a dispute, commercial disputes is more than 3 lakhs, then they have to mandatorily go for a pre-litigation mediation, but not necessarily in other matters. But generally, the courts nowadays encourages, as soon as you file a case in a civil matter, you go in for a mediation, which is referred by the courts directly to a mediation center or a mediator who is on the panel of the courts as such.
All right. So another question from Mr. Amin Merchant. He wants to know, is a private mediation MSA, that is mediation settlement agreement, enforceable?
Of course, it's much. See, what we do is that as there is no standalone law for mediation as such, it's very interesting that I need to share this information. Prior to 2012, the name mediation was not even mentioned anywhere as such in any legal document. In 2002, UNCITRAL came out with a document, a model law, which called as Enforcement of Negotiated Settlement through Conciliation. Okay. So based on which various, this existed even prior to that, and that is the reason our Indian Arbitration Conciliation Act uses the word conciliation, not mediation, borrowing upon the model law prior to 2002. That being the case, mediation, the name mediation was later on introduced by the UNCITRAL, and that's how we have a mediation convention with Singapore Mediation Convention. The difference between conciliation and mediation is that mediators, as we believe, we call it a structured mediation. Structured mediation, mediators have to be trained and there's a structured process involved. In a conciliation, there's no structured process. A mediator need not be a trained, conciliator need not be trained. But when I go and teach mediation practice, then we say, all mediation are conciliation and all conciliations are not mediation. So what we do is that because there's already an existing law on this Arbitration and Conciliation Act, Part 3 talks about conciliation. We treat mediation as a conciliation process, though mediation is done strict. The process is conducted effectively, faithfully as a mediation. The settlement that is drawn, we draw it as the settlement reached under Section 73 of the Arbitration and Conciliation Act, which is final and binding and non-appealable under Section 75, read with Section 30 of the said Act. So the moment the parties sign it and sign the document, settlement agreement, it's deemed to be an award. It's deemed to be an award and as well as a decree, and its final and binding being a consent award. It's final and non-appealable. So definitely it is enforceable, and centers like I represent BIMAC, and we all enforce mediation settlements as in negotiated settlements.
Thank you so much, sir. So the next question is from Deepthi Lakshmi, and she's asked how to deal if a party says that we are biased, how to face that situation.
If a party says that I am biased, I say, thank you very much. I withdraw and ask, if I'm appointed by a center, I request the center to appoint some other mediator. All
right. Anish, I'll request you to share your insights on this. If someone says that you are biased, because you have stressed a lot upon trust building and making the person feel that you are there for them and there's nothing wrong with you coming and approaching and helping them. So your insight.
I wish I had, I wish I had the leeway to exit from that when somebody said that to me, but I can't. So if somebody says, you're being biased right now, I would kind of reflect that statement back to them and ask them just this one question: what makes you feel? Why do you feel that I am biased? And that would open up the avenues for them telling me why they think I'm biased. And firstly, being biased is something which would never happen in a negotiation. But if it does happen and the party does feel that, I am possibly taking the side of the other person, and that's happened many times where they feel that, hey, he's possibly trying to help the other person achieve more than I want to, but it must come out from them. And when we can reflect that question back, why do you believe I'm being biased? What makes you say this word bias, which is a very strong word? And they say, oh no, you're giving the other party more. And I say, what more am I giving the other party that you want? We're now going from the bias into discussion. And that's just actively listening to these key words which they're using with me in conversation, which I'm using to get more out in that statement. And when I hear this, I can then sit with the other party and say, hey, this party feels I'm biased because of this reason. So instead of ending it at you are biased, I have understood why the person has said that I am biased, and then I use that in a negotiation with the opposite party.
Great. So we had Mr. Praveen Sharma, who was my mentor at Lawyers Club India. He used to tell that like, when I am managing people around the organization, and I was in a certain type of situation that I was uncomfortable in, he would always tell me that the solution to miscommunication again is communication. So never give up on communication and keep communicating when you're in that kind of situation. Also, here, there's a huge role that the words that you choose will play in such situations, in such conversations. So there's one question that I will ask right away, extending on to the question that I've already asked you. So Mr. Vinay wants to ask, I find it difficult to work on words and sometimes realize only after an episode that is done that I could have used better words. How to work on that, and will your course help around it?
I think that's a great question by Vinay. But what we need to keep in mind was what we said at the beginning of this course, that communication is not about speaking or about using the words which you believe. It's about listening and using the words which that person wants you to use. And that's very important, that if you can drag the vocabulary of the opposite party into your conversation, if you can drag it into the way you are presenting yourself to that person, that becomes really important. And I'm going to quote you an example over here. That I remember this one time, this happened in another police department where a person had taken someone hostage. And the team reached, the tactical team reached there. And, and unfortunately, not a very trained negotiator was at that scene. And he asked him, hey, what's going on? Is there anything I can do for you? So the person who had taken the other person hostage said, hey, if you get me out of this situation, will you promise to take me to the hospital? Now, our first response when someone says, will you promise to take me to a hospital, is, of course, I mean, I will take you to a hospital. If you want to go to a hospital, I will take you there. So this negotiator responded to that situation saying, of course, I will take you to the hospital. And he shot the hostage and he shot himself, and the situation was over. And later they realized the reason he was asking that was he was testing the hostage negotiator, because this hostage taker just escaped a hospital. He was told that you have to be confined here for the rest of your life because you're undergoing a medical treatment. And he didn't want to be there. He just wanted to escape. So he wanted to know that if he comes out of that hostage situation, is he going to be taken back there? So these words are very important for you to understand. So my response to him at that point of time would be, would you want to go to a hospital? Or is there any reason you're particularly asking me why I would, want to or not help you or render medical help to you? So it's not about your words. It's not about getting your words right or your words wrong. It's about understanding what the other person's words actually mean and absolutely breaking them down into conversations. So when the person says hospital, our first thought is, hey, he needs medical attention. But what if we ask him what he actually needs? And if he had only said, no, I don't really want to go to the hospital because I've just come out of there. The next question could have been, what is it about the hospital that why didn't you want to go back to it? Or, what is it that I can do for you if you don't want to go to the hospital? And then that has facilitated a discussion. So your words are not what we need in a negotiation. It's the other person's words that you're reflecting, putting it back at them, making sense of it, and then using it in conversation.
Amazing. I think we're gonna learn a lot from some such examples and experiences that the trainers are going to share with us in the course. And Thiru sir, if I can come back to you and ask, like, we all know how important words are for lawyers, and while speaking also, and on the documents also. So can you share your insight on this particular question, that if how do we develop on the language that we have to use, and how what to take care of? You've already told us that always keep it simple, but reflecting on to this particular question, how do we develop on the language that we have to use?
Okay, there's a very, very interesting question, and it'll be slightly, not entirely different from the manner in which Anish side of negotiation works. As a mediator, whatever words we use, we have to use it with care. We use what is called the reframing technique. Okay. Imagine if I'm handling a dispute between a husband and wife, and the wife tells, my husband is a drunkard, he beats me. And when I go and talk to the husband and say, your wife says that you're a drunkard and you abuse her, do you think I'll be able to make a progress in my negotiation? I won't. So in mediation, we teach a technique called, as part of the communication program, we teach a technique called reframing. So mediation, BIOMAC conducts mediation program, 45 hours of training. And significant amount goes into communication reframing as to how you use the word, how do you modify? How does it look? If I go to the husband and say, your wife is concerned about your drinking habits, is it better? Or calling a husband, you're a drunkard? So it makes a lot of difference. If one brother has cheated the other brother and says, my brother is cheated, I go to the other brother and say, your brother says you cheated. Or rather, I'll go and say, okay, I wish your brother says that he wish, I think he'd be very happy if you had shared a better portion of the estate or something like that. It all depends upon, word plays a very important role. Though we speak less, but we measure the words, use the right technique and of reframing and put it across. And I'm sorry, Raghav, I need to leave. I'm already in, there's another session going on. I'm already late. I need to join there.
So yes, so first of all, lovely advice that you've given on the question. And secondly, I think we're done with all the questions. Anish, I'll just need you for 5 minutes more because we have 1 or 2 more questions for you. And thank you so much, Thiru sir. It was so much learning from this session, and how you present yourself with the clarity that you have, the knowledge obviously that you have, the experience that you have. It was amazing, and I think it's going to be a great value addition to the course also. Thank you so much.
Thank you very much. Thanks for inviting me, and thanks to you, Anish, for sharing your thoughts. I'm sure, and to all the participants who have been listening to this program very patiently, I'm sure they'll benefit a lot from the course that is being offered by Anish. And I'm going to play a very, really little role in this, but hopefully it'll be helpful. And I'm glad that I'm associated with Lawyers Club as well as Raghav. Anish, thank you very much. Have a wonderful evening and remain safe still. India is not out of COVID, so please remain safe. Thank you very much.
Thank you, Thiru, sir. Thank you.
Thank you, sir. So, Anish, just one last question that I want to ask you. That is from T. Krishna. Also, before moving on, what Thiru sir said, and Anish said, I would just want to summarize that you have to understand what would be the different effects of the language, that the word that you're using or the language that you're using, or the response that you're giving. And secondly, what Thiru sir said, that we have to measure every word and keep all the situations and apprehensions in the mind, that this might happen, this might happen, this might happen, or this might happen. Also keep the worst case scenario and the best case scenario on the two sides, and then come to one solution for the party and for yourself. So, Anish, just one last question, that is from Mr. T. Krishna. Are the parties generally honest, and what is the general trend in negotiation?
Honesty, and honestly, when I speak about honesty, let me be very honest in my response. Everyone who is disputing, or everyone who has a problem, is always going to have a core element which has triggered that problem. And I always say that every crisis has a story, and we cannot judge a person based on the chapters that we meet them on. So it's for us as negotiators to understand whether they have brought honesty to the table, or are they trying to camouflage that story with something we don't know. And based on our ability to actively listen to the situation, actively understand or seek to understand what the person's trying to say, they will tell you eventually whether they're being honest or they're being dishonest. Remember, you will always be caught in a lie. When you're dealing with a system, when you're dealing with a criminal justice administration, we seek to understand. We seek to understand where the person is actually trying to frame the other person, and that could go against them. And a lot of times when I have spoken with people at that moment, or the edge, as I call it, they haven't been very honest with me, but they have seen my side. They have seen that, hey, this guy is not here to give me crap. This guy is not here to lie to me about what's going to happen. Maybe I can be as honest with him. And when will people confide in you? Is when they actually trust you. Now, trust is a very, very long process to achieve, but we try to achieve it immediately. We try to get it. Hey, we're here. We're going to be that instrument of change. We're going to be that superhero that's come down on this planet to help you get past that moment. But that's not how it works. So that again takes me back to your question. When do you know when to pull out? There is no pulling out. Just stay with them, be there for them, and trust eventually develops. Trust eventually leads them to even being very honest. And I've seen that. I've seen that with hundreds and thousands of cases, that it's not started on the right tone. It's not started with them telling me everything. But by the end of it, when I'm probing back into it, hey, the truth comes out. And the truth allows them to actually either succeed or fail. And even if it's failure, we need to show them that rehabilitation is okay. It's okay to not be okay, as we say, but it's not okay to not want to be okay.
Thank you so much, Anish. We have received one more question, if you allow.
Yeah.
So this is an anonymous question. The person wants to ask, what are the various hurdles that a negotiator can face, and can you help us with an example?
Yeah. One of the hurdles which I believe negotiators face is themselves. If you yourself are your greatest hurdle in a negotiation, it is not the client. If you're not ready to be there at that point of time to help someone to negotiate, just don't be there. So your only hurdle, to be very honest, is you. Now, if you can get past that, hey, I am there till this resolves, you are going to actually cross a lot of hurdles for your client and also the opposite party. So this is what I believe you need to work on, is working on yourself, so that you don't become a hurdle to that negotiation. Are there other visible hurdles? There are things which are not in your control. Like, for example, sometimes I've seen that I go out into communities and I tell them that, hey, your police officers are always going to be there for you. And we guys are doing our best to show you a very powerful and positive side of law enforcement. But then on that one day, there could be one officer having a very bad day. And that could come out in that discussion. And, that community could come back to me and say, hey, you said that you guys are going to be there for us, but what happened on that day? So there are a lot of things which are in your hands, but there are many things which are, again, not in your hands. I'm not going to speak about things such as corruption, or such as, how systems are faulty, or how people make and break that. I'm talking from a very honest viewpoint, that if we can be there for people and show them that hurdles are meant to go around, I think there is no hurdle.
Great. Thank you so much, Anish. Also, because of the paucity of time, we cannot take questions from the participants anymore. So I apologize, Hiral, Mridul, Sunit ji, CA, Mehak, and everyone who's there who've asked questions. So I'm really thankful, Anish. I know you have back-to-back things on your agenda from day to the evening, and still you have taken and given us so much time, and are going to give us so much time for the course again. So thank you so much for being here, and I'll trouble you again very soon.
Not at all, Raghav. I love that you're here, and it's no trouble at all. And thank you all the attendees who were a part of this. And I'll really look forward to seeing them at the course, so I can actually elaborate myself and quote a lot of examples from my time with law enforcement and the things that I'm doing now. And I'm sure Thiru sir, if he was here, would have said the same thing, that on behalf of him and me, we look forward to seeing you at the negotiation blueprint. Thank you for having me, Raghav.
Thank you so much, Anish. Thank you all the participants. I'll share the link of the online learning at LCA, and you can check out all the courses that are already there, and you can enroll for the negotiation blueprint course by Thiru sir and Anish when it is upside. Thank you so much.